Is it illegal to keep lost property in Canada? In Canada, the laws regarding lost property are generally similar to those in the United States. Keeping lost property without making reasonable efforts to return it to its rightful owner is generally regarded as unlawful. The legal principle in Canada is often referred to as theft by finding or misappropriation of lost property. If you find lost property, you are expected to take reasonable steps to locate the owner and return the item. This may involve notifying the police, posting notices, or contacting local authorities. Failing to make these efforts and deciding to keep the property for yourself can potentially lead to criminal charges of theft or possession of stolen property. The potential penalties for possession of stolen property in Canada are outlined in the Criminal Code of Canada and can range from fines to imprisonment. Here is a general overview. Summary conviction: for less serious cases where the value of the stolen property is relatively low, the offense may be prosecuted by summary conviction. The maximum penalty for possession of stolen property under summary conviction is typically a fine not exceeding $5,000 and/or imprisonment for a term not exceeding 2 years less a day. Indictable offense: for more serious cases, the offense may be prosecuted by way of indictment. The penalties for possession of stolen property as an indictable offense can be more severe. If the Crown proceeds by indictment, the potential penalties may include imprisonment for a term of up to 10 years, depending on the circumstances of the case. When determining the penalties for possession of stolen property in Canada, several factors can influence the outcome. Value of the property: the value of the stolen property can be a significant factor in determining the severity of the offense and the potential penalties. Generally, the higher the value of the property, the more serious the offense is considered. Knowledge and intent: the court may consider whether the person in possession of the stolen property knew or should have known that the item was stolen. If there is evidence to suggest that the person knowingly possessed stolen property, it may result in more severe penalties compared to someone who unknowingly possessed it. Role in the offense: if the person in possession of stolen property played a direct or indirect role in the theft or acquisition of the property, it can impact the severity of the charges and penalties. This can include factors such as aiding, abetting, or facilitating the theft. Criminal history: the defendant's criminal record and previous convictions can be taken into account when determining penalties. Repeat offenders or individuals with a history of similar offenses may face more severe consequences. Cooperation with authorities: the level of cooperation with law enforcement authorities can also be a consideration. If the person in possession of stolen property actively assists in the investigation, returns the property promptly, or provides information about the theft, it may be viewed more favorably by the court. If you or someone you know is facing charges related to possession of stolen property in Canada, it's crucial to consult with a qualified legal professional who can provide accurate advice based on the specific jurisdiction and circumstances involved.